I don't think so. Maybe.
Well, we're going to find out.
Yeah.
That's the negative.
Okay. Because I would be like, where's our ice
I
cream?
know, because they make bubble gum, which is my favorite flavor. Which
Oh, wow. I've never tried that.
I'm weird. I know.
We're
I never
saying
got
no?
through it.
I mean, I've never tried it. I guess I
It
can't.
has little
I can't
pieces of
knock
gum
it,
in it. So
But can we say no to something until we tried it? We're not setting a great example for children. We're like,
I've
try
had
the spinach.
bubblegum, like medicine and stuff. I don't.
yeah, I'm a bubble gum freak. So I'm
Well,
going
people
to bring y'all bubble gum ice cream now.
And
Thank
bubblegum
you.
kids
I'll
are
bring
good,
normal
too.
flavors too.
Okay. All right. So last time we were here, there was discovery, school records, daycare records don't exist. Need a copy of the same. Therapy notes until December. So where are we on all of this? Discovery.
So I think the only thing we were really lacking was that in the SANE, she has the SANE records, but in this particular SANE, for some reason, they did a video of it, which I've never seen before. But we have made some progress because it's not the normal place you request it. You request it from somewhere else. And we have made that request and we followed up on it a couple times. I think our next step is we're going to have to send an investigator over there. But we have not gotten it yet.
All right. So what is outstanding?
Outstanding is the therapist Kelly Bernstein records. I think we only have, it stops, I believe.
It's, I want to say it's close to around the March or April time, early March.
Of last year. Yeah, so the remainder of the Kelly Bernstein counseling records, the state did provide a batch of them, but I gave the dates, I think, to Brittany about what's outstanding.
Okay.
The child's counseling records from school, the SANE video, there was no daycare, and then the cell phone dump that occurred a year ago, we do not have any information on.
And we've reached out to Shirts PD. I think the next step is we're going to have to make an appointment with Shirts PD to go there and look at their file.
All right. So let me just tell you what's going to happen. I'm going to give you guys the final discovery date. It's going to be in 30 days. And any discovery you don't have, if there's a problem with the cell phone dump, whoever that is, people need to subpoena people to be here and do a subpoena Dukas take them and have them bring the records. All right, Ms. Ferguson,
Judge,
yes.
One more issue. Oops, sorry. I did a comprehensive discovery motion and order, and the states agreed to everything within the motion except for one issue. So we needed the court to hear us on that.
Okay, I don't have that motion.
Oh, I have a copy for you.
Can you all look up the motion? What's the title of the motion?
Motion for discovery. May I approach, Your Honor?
Yes, it's a motion for discovery from defense. And may I use this copy?
Yes, ma'am.
All right, so
And I have the order, Judge, that outlines everything that we've agreed to with a few changes that Ms. Mitchell and I have agreed to. There's just one issue. I believe it's the last on page 5, number 2.
all right, let me go. I think I may have the wrong, you say page 5, what is
That's the motion, maybe not the order.
yes, I have the motion. So which,
You can, it's marked up, but you can look at it.
okay, sure.
Oh, did I just give her my motion?
All right, I wrote on the one you gave.
Oh, see, I don't have
I know. I'm like, that's why I need a little table right here. Here, hold this.
So all medical and psychiatric reports. Let me see if I can find that in the motion.
Judge, it's on the second, I'm sorry. These pages aren't numbered, but it's on this page, Judge, the third from the last page where it says state evidence. And it is number 2 at the top.
Okay, state evidence. Number two, the all medical records of Alexandra Reed. Is that the one?
Yes, ma'am.
All right. So this is what we're going to do because you all say you have everything else agreed to. If you all can bring me an order of what you all agreed to, and then we'll go on a record and address number two.
Okay, I have the order of what we've agreed to, Judge.
Okay,
I have
awesome.
it. It has just those minor changes.
Okay, that's fine.
And this order that you all agreed to with the minor changes.
On that one, it's stage 5,
Okay.
number 2.
All right, we're going to go on the record. Court is calling 2022 CR 11724, State of Texas versus Jordan Luke Robbins. Can I have parties announced for the record for the state,
Brittany Mitchell for the state.
for the defense?
Amy Owen for the defense.
All right, and are you Mr. Robbins?
Yes, ma'am.
All right, the court has been tendered an order, and it's an order for discovery. State, have you had a chance to review the defense's order for discovery?
I have, Your Honor.
And it's the court's understanding that the items that are marked as agreed with the changes are what the state has agreed to. Is that correct?
Correct.
All right. And state, if you'll initial 1 and 2. And my understanding is that the only disagreement is number 2, and the defense is requesting all medical records of Alexandra Reed, mother of the complainant, relating to her traumatic brain injury, including any and all hospitalizations of Alexandra Reed. Is that correct?
Yes, Your Honor.
All right, defense, it's your motion.
Yes, Your Honor. So I would like to move to admit Defense Exhibit 1. I've already tendered a copy to the state. I don't believe they have any objection.
No, no objection. Your Honor.
All right,
Your Honor, may I approach?
yes, defense exhibit number 1 is admitted. All right, excuse me, guys, we're on the record, so you all need to either move down there or not talk while we're on the record.
So Judge, this is the criminal history of Alexandra Reed, and what it indicates is that in December 30th of 2012, Miss Reed suffered a traumatic brain injury as a result of her ag assault with a deadly weapon and an intox assault in Comal County. Now, the research we've done with some of our experts thus far has indicated that traumatic brain injury can result in hallucinations, false memory. Different things can happen within the brain depending on where the injury is. Around the time of this outcry, we see within the civil discovery that we obtained through our civil case that she has been hospitalized. There's payments to emergency room doctors. There was payments to, it looks like co-pays within that civil discovery right around the time of this outcry. It also can result in seizures and different things can happen. And so it's our position that this is, our client's completely innocent of this. And so the mother in this case, I believe that could be relevant. I told the state that I'm open and would agree if the court was so inclined. I know it's a big ask because I don't know how voluminous it would be for the court to do an in-camera inspection to see if anything's exculpatory within those records. We're not on a fishing expedition. It's not to just, delve into anything personal it's simply related to her traumatic brain injury and what could be occurring with mom that we believe that she's coached the child into doing this. So that's the reason why we're asking for it. And I think that it could contain exculpatory information and the state has objected to that request, Your Honor.
State.
Your Honor, obviously Alexandra Reed is the mother of our victim, not the victim herself. It seems this is an incident from 2012. I don't see how the mother's condition is relevant to what her daughter is saying is her memory. Her daughter doesn't have any injury, the mom does. I'm not privy to their experts and how necessarily this would affect that. Additionally, I don't know exactly what we would even subpoena.
Well, let me ask this. First off, is the mother the outcry alleged to be the outcry?
Yes, ma'am.
All right. So, of course, the court will read, no matter how many pages it is, the court will read what is whatever is given to the court. As far as the state being responsible for obtaining these records, I don't think that's in their purview to obtain. However, defense, if you want to obtain the records and anybody wants me to review them, I will review them, but I don't think it's because the mother is not the complaining witness. I don't see how it's the state's duty to have those records. And with regards to an outcry witness, the outcry is not to be used as evidence in the sense that it's true. It's merely that this is the first adult that the person told. I understand your argument though, defense.
And Judge, I think the issue with us obtaining them is that she would have to execute a HIPAA release for us to be able to even get those records. I mean, I think if the state subpoenaed them and gave them to the court and the court did the in-camera review, I think that's the only mechanism to be able to get them. I can't just subpoena her HIPAA, her protected medical information.
Well, I think that it can be subpoenaed, and if somebody wants to squash the subpoena, they can bring an attorney in to seek to do that.
Okay. All right.
And then I will hear that motion.
Okay. That sounds fair, Judge.
Okay.
Okay.
All right. So I'll deny number 2. Is there anything else?
I don't think so.
I think
it's
that's
just a
all.
matter of us getting all the discovery done in that 30 days.
And defense, do you want to withdraw defense's
Yes.
exhibit number 1?
I will withdraw it.
All right. Any objection?
No.
All right. So Dinah, defense exhibit number 1 is being withdrawn. And I'm going to give you all a 30-day reset. This is the last, I'm going to give you all a 45-day reset. This
Okay.
is the last reset for discovery. If there is something that someone is not turning over that everyone feels should be turned over, those persons need to be subpoenaed. If it is not done and we go to a jury trial, then things may end up being excluded.
Understood, Your Honor.
All right, Ms. Fergus, can I have a 45-day reset on Mr. Robbins?
July 13th.
All right, July 13th.
Sounds good.
All right, just get a reset form and then you're all excused. Thank
Thank you,
you.
Judge. Maybe be excused.
If the